Hello, thank you for joining us today. I'm Lauren Dexter Burns with St. John Associates Physician Recruiting. Today, we are going to talk about a topic our consultants frequently cover with their candidates, and that is physician employment contract negotiation. But before we launch into that, just a little about us and how we can help physicians like you with your job search. SJA has been a national leader in physician recruiting since 1991, so for over 33 years. We work with physicians in any stage of their career, residents, fellows, practicing, early practicing, later career practicing. Our consultants serve specialties in all 50 states and they work exclusively in specific markets. So they have a deep network of employers across the country and extensive knowledge of their specialty market. A handful of them have actually worked with us for over a decade, so they are truly experts in their field. You will only work with the recruiter in charge of your specialty. You will not be passed around from person to person. They will be with you from start through signing. And our purpose essentially is just to make your search easier and more efficient. Our consultants like to say they're searching while you're sleeping or while you're on call. You know, it's easy to feel like you're falling behind in your search or you don't have time to fully explore your options. And so that is why we are such a great resource for physicians. Our searches are always free to the job seeking physician. There is no fee for you to be matched to an employer, and you can actually start browsing our jobs at stjohnjobs.com. You can also create an account, sign up for job alerts. Job alerts work that you'll receive an email as soon as a brand new job in your specialty and location becomes available. We also have other webinars and resources available. We just had a webinar with a colleague of today's guest, which covered immigration and visa applications for physicians. So if that applies to you, be sure to check that out. Again, you can find all of that and more at stjohnjobs.com. So now we'll move into the topic at hand. Nearly half of physicians leave their job within 2 years. That figures from the AMA, going back to what I mentioned before. It speaks to how difficult the job search can be, and clearly many settle for what they get quickly instead of being able to conduct a quality search. And maybe part of that dissatisfaction comes through hurrying through your contract without having an expert to review it. Topics you can see that we will cover today that includes negotiation preparation, how to evaluate your contract, strategies and tactics for negotiation, red flags and when to walk away, and when to involve an attorney like our guest, who we are very excited to talk to. Jim Whitlatch is a partner at Bunger and Robertson. Jim practices in all facets of health law and employment law, handling medical malpractice defense, hospital and healthcare law, planning, including HIPAA, Stark, and EMTALA, fraud and abuse, contracts, joint ventures, tax exemption, peer review, and physician and hospital practices. Jim was a faculty member at Indiana University from 1989 to 2023, teaching legal aspects of healthcare. He has also served as the chair of the ISBA Health Law section and as a member of the American Health Lawyers Association. He's been a speaker and author for continuing education seminars for lawyers and other professionals on a variety of topics and has contributed to articles in publications for the healthcare field. Jim, thank you so much for joining us today.
Thank you. I'm happy to be here.
All right, let's go ahead and get started. Let's start talking about the different types of employment contracts our physicians can expect.
All right. And I guess before I get into that, I just want to kind of piggyback on what you just said as far as the importance of contracts. One of the things I always tell clients, physicians, healthcare providers when they come to see me about a contract is that the most important thing for you to look at in a contract or as you're looking at a job is that you're going to be working somewhere that you're comfortable with where you're working. It's the job you want, that you're comfortable with the people that you're going to be working with, and that you can trust those individuals. The contract is extremely important, but so is that aspect that you need to make sure that you're comfortable with the people that you're going to go be working with. A contract, oftentimes you may sign a contract and not even have to look at it again during your employment term. But what we want to do and what I want to talk about during this presentation is the importance of understanding what a contract is, what it means, what the terms of a contract are, and how they may impact you, and then the importance of the different terms of the contracts and how they may govern your employment with or your arrangement with any kind of employer. So, getting into that in respect to the types of employment contracts, many years ago, probably now 20 years ago, most physicians were either in a solo practice on their own as sole proprietors or were part of a independent partnership, would oftentimes have medical staff privileges at a local hospital and would be independent contractors at those hospitals. Starting 20 years or so ago, the model began to change and has significantly changed since that time, where most physicians are now employed in a traditional employer-employee relationship. And their employer may be a hospital, may be a large physician group, maybe a not-for-profit, maybe several different types of organizations can employ you. But the definition of an employment is where you are working for someone else, you are subject to their direction, which is something to be important, is important and to understand. And you are going to be paid. There's going to be taxes withheld. They're going to pay part of your self-employment taxes. It's not an independent contractor type of arrangement. The second type, the more traditional type of arrangement you have, may be becoming a partner in a physician practice of some sort, where you are a partner in that project. You may be paid as a partner, but you may also become an employee of that partnership. It oftentimes will be what is known as a professional corporation or a limited liability company, that you might be a partner. You may have some equity ownership in that entity, but you still might be or would typically be an employee of that, even if you have an ownership interest in that practice. You can also be part of an academic, university, or teaching situation, or hospital, academic tied to a university or a teaching position. Typically, when you're in an academic situation or setting, there's typically two types of arrangements that you may have there. One is an academic appointment, where you're appointed and you're subject to the academic rules of the university in that appointment. That may include things like tenure and expectations of teaching and research and writing and things like that. And then oftentimes in the physician area, at least, you will also typically probably have a separate contract with the more clinical side of being in an academic setting, which would be more akin to what you would have as an employed arrangement. So you would have an academic appointment and you would typically have an employment contract to provide clinical services associated with that academic appointment. And then the final option that we discuss here is locum tenens. And that is where you work for a company who then places physicians in areas where there is a need for a physician in a certain specialty, and you typically sign short-term contracts. You're typically not working for the hospital that you're assigned to. You're working for your locums company that then contracts with the hospital to provide your services. So those are the different types of employment contracts. How to negotiate and how to prepare yourself for negotiation. Certainly, getting information, review salary surveys and regional benchmarks. There's a number of those out in the marketplace. Many of them require a proprietary subscription to those. There's Sullivan Cotter, there's MGMA, there's a bunch of different types of physician salary surveys out there that can give you information about, in your specialty with your training, what's the bottom 25% compensation, what's the mid 50, what's the top 75%. They can oftentimes also give you information about what the WRVU expectations may be, what the RVU reimbursement rate may be. They can give you lots of information, but also don't hesitate to use resources you have. People that you maybe have worked with or trained with if you're just starting out, who may be able to provide you information about what the salary ranges are in your field in a given area. Certainly, your contact and the people that you're working with at St. John's can give you and provide you much of that information as well. So, having that information in advance is very helpful. Um, Researching specialty specific data is important so you know what your specialty is involved with. And certainly in some areas there's large shortages and you're in a better position to negotiate those types of situations. Understand what your personal priorities are and what's non-negotiable to you, whether it's family, work-life balance, whether it's geographic location to be close to family or friends, whether it's that you have that call schedule is important to you, that not having a non-compete or how that non-compete reads. Just understand what your priorities are. Is it pay? Is it work-life balance? What is it? Build a negotiation team. Certainly, an attorney, mentors that you've worked with or that have trained you can be good resources. Your physician recruiter at St. John's, all of those folks can be important in that process. And then consider timing for optimal negotiation. You certainly, oftentimes you're starting a year or more, up to 6 to 9 months before you're actually going to be starting a job. That gives you some times, but it's inevitable. And I look at a lot of contracts for physicians all over the country, people that referred to me by St. John's, but also a number of other people for and contracts all over the country. And inevitably, even if it seems like they have a lot of time, it always comes down, oh, I got to get back to them next week or something like that. So give yourself as much time as you can because it helps you understand, it helps you make the right decision, and it helps you be in a better negotiation position. The general timeline, yes, you're going to have that initial discussion and interest, oftentimes a year out or more. You're then going to typically that can morph into a letter of intent, which basically is a letter that sets forth the general guidelines of what the offer or what an offer may look like. It's important to understand, and we'll get to this in a second, but it's important to understand what a letter of intent is and what a letter of intent is not. So we'll talk about that here in a second. Then from there, you go to the contract review and negotiation, allowing yourself time to have that process. And then once you get all of that done, you go to the final agreement and signing. So we'll break that down in a little bit more detail here in the following screens. Um, how does a letter of intent factor into the negotiation process? As mentioned, it outlines the basic terms before the full contract is offered. So it's going to say, what's the salary? How am I going to be compensated? What's the length of the contract is? What benefits I may have? What type of work hours, duties, expectations you may have? All of that can be spelled out in a letter of intent. It also is a way to demonstrate serious intent or interest from both parties. Oftentimes, a letter of intent can be signed, but that doesn't make it a binding contract. It will typically say the parties agree from this point forward to enter into negotiations to try to reach a negotiated binding contract. A letter of intent will typically say that this letter of intent is not a binding legal document or agreement, and is not enforceable by either side against the other. So understand again what it is. It's going to spell out what you're hoping to do, but it's not the end result yet. The letter of intent sets framework for the detailed negotiations. We're going to get a contract for you. And then, as I stated, generally not legal binding, but establishes expectations. What do we do when we evaluate your contract? So certainly everybody's concerned and wants to know about compensation. What's the salary going to be? How's that going to be? Is it going to be a flat fee? Is it going to be a guaranteed base salary? Do I have the ability to enter bonuses? Is it going to be based upon production or gross receipts, or how's it going to be determined? What are the benefits going to be? And then the contract terms, practice conditions and responsibilities. So any contract is going to have a lot of information about um, who you're working for, what you're going to want to know as far as your relationship with your employer. And the most of these contracts I'm talking about, because the most of them that you're going to be seeing in today's market are going to be some variation of an employment contract. This is really talking about employment contracts here, not partnerships or not necessarily locums contracts, but contract terms and employment contracts. So one of the first things that you're going to think about in an employment contract is the term of that contract. What's the term? Is it a 1 year contract, 2 year contract, 3 year contract, 5 year contract? Let me first say that the length of the contract probably makes very little difference. And the reason I say that is because almost every contract you're going to see, and I would venture to say every contract you're going to see, is going to have a without cause termination provision in it. And what I mean with without cause is that it's going to say that either you as the physician or the employer can terminate the contract that you sign at any time without cause. They don't have to have a reason. They don't have to show a breach of the contract. You don't have to show a breach of the contract. And the most typical time frame that either side can terminate a contract without cause is 90 days. So if you have a 5 year contract, you may say, great, I've got a 5 year contract. I'm locked into 5 years. No, if there's a without cause termination clause, which there's going to be, you're really only locked in for 90 days because that's the time frame that you could sign it one day and the next day they could give you notice that something came up or something they didn't like or their business, they lost a huge contract, so they're not going to be able to afford to pay you. They could give you notice the day after you sign that the contract is going to be terminated upon 90 days notice, and the contract would be terminated after they've given you that 90 days notice. So where we talk about the term of the contract, that's sort of unimportant because every contract with very, very few, almost non-existent exceptions are going to have a without cause termination provision. Typically 90 days. I've seen them as short as 30 days, and I've seen them as long as 180 days. Typically, do you see them longer than that, nor do you see them shorter than 30 days? But that means that they can be terminated. And that's either way. If you get in a position and you're not happy with your position, hence the idea that people leave after in less than 2 years, you can give notice as well and don't have to have a reason and can remove yourself from the contract. You do want to make sure that there's no provisions in that contract that could create a problem for you. I have seen a number of times, not never with physicians, but I've seen them with physician assistants who have a provision that if they terminate the contract early, even if they have the right to do it, that they might have to pay to have because the employer can't find somebody quickly, that the employer may say, well, you owe me money until I can find somebody else to replace you. I'd be very careful about that kind of language. You are not typically, I've never seen that in a physician contract. I've seen it several times in PA contracts, particularly connected to dermatology practices, quite frankly. So be aware that the term is the term, but you're always going to have that without cause termination clause. You're also going to typically have a clause that allows the contract to be terminated immediately by one or both sides if there is for cause termination. You breach the contract somewhat for some reason, you lose your license, you're terminated from the Medicare, CMS, Medicare, Medicaid system, something like that. The contract will typically say that's cause and you can be terminated immediately. It's rare that either side tries to terminate a contract for cause. The reason for that is it's so much easier. You don't have to get into a fight about whether or not you had the right to terminate for cause or not terminate for cause. You can just terminate the contract without cause and be done with the contract at that point without having to dispute, because it's hard to dispute when you can have the right to terminate it without even having to have a reason for that termination. So while every contract's going to contain a without cause termination provision, it's rare that those are utilized by either side. They're usually, if they want to end a contractual relationship with somebody, they'll do it under the without cause termination provision. Typically, that without cause termination provision, as I said, is typically a 90 days notice. Contracts will oftentimes say that they have to give you 90 days notice and they're required to pay you during that 90 days, but they can also tell you that they don't want you to work during that 90 days. It's oftentimes easier and more comfortable if you give notice of termination of a contract to the employer doesn't want you around anymore. Even if it's the most amicable separation as it can be, it still makes people uncomfortable to have somebody around that's a lame duck, so to speak. And they will oftentimes, whether you terminate and say, I'm giving you my 90 days notice, or if they terminate and say, we're giving you your 90 days notice, the employer will oftentimes say that we don't want you around anymore. This was your last day. We will, because we have to give you 90 days notice, we will continue to pay you your salary during that 90 days, but we do not want, nor do we expect you to come into work during that 90-day period. So those are some of the provisions as far as termination, those types of things to be aware of in a typical contract. I think we'll talk about other provisions more as we get into this a little bit further along, but non-compete provisions are something that's important. Non-solicitation provisions are important. And then who do you report to? The contract, one of the things that you want to be aware of in a contract is that you're going to be answerable to a board of directors or to a president of the group or the president of the hospital, and they direct when and where you provide your practice or where and when you provide your services. So the location of where you're going to be practicing is always important, and especially if you're in a large group or a large hospital system that has a wide geographic area, be aware of how that location of practice is written, because it will typically say they can assign you where they want to assign you. They may tell you when you initially sign the contract that you're going to be in this office at this location, but things change. And the contract will probably contain language that says they can assign you wherever they want to assign you. And so, you might initial assignment that you think you're going to be at for your whole career is 5 miles from where you live. Well, they've got an office or a hospital that's 75 miles away, and they may decide because of resources or need or whatever that they're going to assign you to that office or hospital that's 75 miles away, and the contract may allow them to do that. It's always nice to have language that they consult with you before doing that, or that you need to agree to that before they can assign you somewhere else. But be aware that they're probably going to want to retain the right to direct where you provide care. They're also going to direct or retain control of when and where you provide that care. And what I mean by when, your hours, your days, when you can take time off, what your on-call schedule is. All of that is going to be contained in the contract. And some of it's going to be spelled out specifically, some is not going to be spelled out specifically, and you're going to need to think about what you want to try to make sure is spelled out that's important to you. Things like call coverage. You may be the new person at the office. Are you going to get stuck with all the call coverage? Other things that can have to do, there may be administrative duties that you have to fulfill, medical staff duties, administrative duties. Be aware of how they assign that, and they're going to be able to assign that to you. How much of that is going to be expected, how you can limit that expectation. Understand that particularly if you're in a part of a uh, compensation system that's based upon production, collections, RVUs, that the more that they do things, assign you to things that can't generate collections or can't generate RVUs, that will affect ultimately your bottom line income, and they'll have the right to assign you to do those types of things. So be aware of that. Be aware of what input you have into it. Contracts will oftentimes talk about how you are to work for them full time. Be aware of what that means, what their expectations are regarding that full-time employment. They're going to want you not to do anything for anyone else while you're employed by them. Typically, a contract will provide it and contain a provision that says that you will work full time for them. You can't work for anybody else in providing medical services or in the medical realm without getting their advance approval. So you can't do volunteer work. You can't necessarily teach unless it's part of an academic appointment under the contract. You can't work for drug or device companies without their approval. So be aware of that. If doing some of that is important to you, you're going to want to address that up front, or at least know what requirements you have if you want to do some things on your own time that are related to providing your professional medical services. And so the other thing to be aware of in that sort of same genre is if you're a tinkerer, if you're an inventor, if you're somebody that has an idea that they want to expand on, that they want to invent something, they want to write an article, they want to write something that could be copyrighted or patented. The general law is when you're an employee is if you do something while you're an employee, even if you don't do it at work, and even if you don't do it using their resources, they may very well, probably will own whatever you develop. So you want to be aware of what their policies are regarding development of any kind of intellectual property, and be out ahead of that before you start uh, developing the next great catheter or the next great procedure in your basement or somewhere else. You're going to want to understand what their policy is. Oftentimes, it's mentioned in the contract, and you also may want to consult before you start that or get too far down the road. You're going to want to consult with an intellectual property attorney that can help you through that process and understand what's involved in that kind of scenario. So those are some other issues that can come up in a contract. Um, Base salary, compensation based salary versus productivity based models. Oftentimes, for 1, 2, maybe 3 years, you'll get a base guaranteed salary. Most employers like to go away from that relatively quickly to a productivity based model. Excuse me. And sometimes they'll have a combination of two. Sometimes you'll have a base salary, but you'll be eligible to earn a bonus subject to some type of productivity based incentives or other types of incentives regarding quality care, reports of interactions with patients, things like that. So it may be a combination of both. But typically, most contracts, most employers are going to want to try to move you to a productivity-based model as quickly as they can for several reasons. One is that that makes you arguably work harder and more productive. And secondly, they don't pay somebody a base salary and they're not getting the return out of that base salary that they want to get from that. So, oftentimes, the two most prominent ways to do a productivity-based model is through RVUs, relative value units, which you were probably all familiar with, but that's based upon certain coding, how much time is assigned to that activity. And then you have an RVU rate, which gives you an hourly rate for the time assigned to that RVU that you have. And that is how your salary is based upon the RVUs you generate based upon the multiplication of that by your RVU rate. That's a very common type of compensation now. It's popular because it's easy, it gives credit for different types of things you do. It can be nice for a physician because it's not based, collections are based upon things like the insurer mix, which insurers pay more. If you don't have collections, if you have a lot of patients that don't pay, collection based, which is based upon the actual collections that you receive, the actual money you get from the services you actually provide, can be based upon that collection model. The RVU is oftentimes seen as more fair because it gives you a rate and an amount for the type of work you're doing, and it's not based upon whether you actually get compensated for that or not. So you're going to want to know what RVUs, how they calculate those. You're going to want to know what your rate is, if that's a fair rate. And you're going to want to know if they will give you, there's many things you may do, or at least some things that you may do that do not have an RVU rate assigned to them. Many times employers will assign an RVU rate to certain things so that if you're doing something that doesn't have an RVU rate, you're not just wasting your time. The employer will assign an RVU to that so it doesn't undermine your compensation in that type of situation. Another type of compensation that can be on top of that can be bonus structures based upon certain quality metrics on patient satisfaction returns or number of patients you're able to see or other metrics, how quickly you get your medical records turned around. Other quality metrics can also lead to additional bonus funds to those to you in your compensation area. Benefit packages and their true value, certainly benefit packages that we're talking to are going to be things like health insurance, retirement plans, vacation. Vacation time for physicians is a very tricky area, especially when you go to a compensation-based model, because when you do that, there's no such thing as a paid vacation once you go to a compensation model that's based upon productivity, because if you're gone from the practice and not seeing patients, you're not being productive, you're not generating RVUs, you're not generating billing that makes collections, so you're not getting paid. And unless you're on a base salary where you get paid, even if you do go on vacation, where you do have vacation time off and you need to take vacation time off and you need to do all those things, but understand that your employer may say you have 3 weeks off or 4 weeks off or whatever. You're not going to be, if you're on a production based system, you're not going to be compensated for that time that you're off. So that's an important thing to think about. As far as other benefits, those are all important. They do take a role in your practice and in the value of the compensation that you're going to get. However, I tell people, you want good benefits. I typically see that most practices are going to be giving similar type benefits. I'm not too worried about uh, physicians being treated unfairly in benefit packages because of federal laws called ERISA. It's very difficult for any kind of employer to give one set of employees very fair or better benefits than another area of employees. So you're going to get, generally speaking, the same benefits that the people who are high up in the organization that employs you get. If the people high up in the organization cut their benefits or cut your benefits, they're also going to have to cut their own benefits. So benefits are generally everybody gets treated pretty fairly on that benefits package. But it is important to factor that in when you're comparing different contracts as to how good are those benefits. And then the other thing that oftentimes will be discussed is partnership ownership considerations. You will sometimes get a contract that says after a year or 2 years, or after you are able to generate these types of RVUs, we will consider you for partnership or an ownership interest in the business. And they might even give you a little bit of the information about what that means. What it doesn't mean is that you're going to be guaranteed ownership or partnership when you sign a contract at the very beginning. Nobody is going to guarantee, or very few people is going to guarantee you a partnership or ownership interest. They may say that we'll talk with you about it after a year, but it will also say that we're not bound to provide you partnership, just like you wouldn't want to be bound to join a partnership. You may not like those people, and you don't want to say before you've worked with them for a year that I agree that I absolutely will become your partner after a year. That may be the last thing you want to do after a year. And that's the same on the other end, is they aren't going to commit themselves to being a partner until they know you, and then they might talk about partnership. And then you're going to have a whole nother set of documents that are going to be separate from your employment contract that are going to govern how do you buy into this partnership or corporation or buy shares. How do you do that? You're going to have things like a buy sell agreement that's going to talk about how you buy in and how you can sell, those types of things. So that comes down the road. They may mention it in their contract, but there's not going to be anything binding in your initial employment contract about that partnership or ownership. So the fact that it's not a huge incentive to you that somebody tells you, oh yeah, we'll consider you for partnership over after a year. Yeah, they're just going to consider you. Doesn't mean that you're going to be there. So that's what to think about there. Contract terms, scope of practice, and clinical autonomy. I talked about this and touched on this as far as location a little bit. The contract's going to say that you're a professional, you're trained, you ethically are going to have an obligation to make decisions about the best medical care for the patients that you're going to be seeing. That's what your medical training is all about. And nobody's going to be trying to direct specifically how you practice medicine. Now, they may have policies, they may have practice guidelines. All of those things will be incorporated into the contract. And I always tell people the contract's going to say that you agree to be bound by the policies and procedures of this practice. So that becomes part of your contract. So you need to make sure that you see those policies and procedures so you know that what you're going to be bound to in that practice. So ask for the policies and procedures, practice guidelines that they're asking you to comply with. See those because you're agreeing to be bound by them when you sign that contract. Call schedule and coverage requirements are important. Be aware of that. CME allowances and sabbatical opportunities, that's part of your benefits. And you're going to see how much are they going to provide? Are they going to provide? Are they going to cover your fees to become board certified or to maintain your board certification? Are they going to pay fees at hospitals to maintain medical staff privileges? What all are they going to be doing there? Certainly, your researching and teaching responsibilities, particularly if you have that academic appointment. And then we've already touched on the idea of practice location. Remember, when you're employed by somebody, while you have patients, those patients are assigned to you by the employer. Those are not your patients if you walk across the street in 5 years and hang up your own shingle. Those are still the patients of the practice. Now, those patients have the right to switch their allegiance to you at another location under typical circumstances, but patients are assigned to you by the practice when you're in an employment relationship, which goes back to that clinical autonomy issue. Legal protections, malpractice, professional liability insurance is particularly important to have. One of the questions you're going to want to ask is, what is the total amount of insurance that I have? And you're going to hear two numbers typically. And the number you'll almost always see in a contract is 1 million, 3 million. That means is that they're telling you that you will have a minimum of $1 million per occurrence of malpractice in any given year, and you will have up to an aggregate of $3 million for any and all cases that have been filed against you in any given year. It's based upon a 1 year term. Frankly, that is not very much insurance, in my opinion, and they most always have more than that. But what they typically put in their contracts is that they're going to provide you with a minimum of 1 million, 3 million. What you want to ask them is, okay, that's the minimum, but how much are you actually carrying on your physicians? Are you carrying for your practice? Do you have excess coverage that would cover me in this situation? Why that amount of coverage is important to you is because, let's say it's $1 million per occurrence. You have a malpractice claim against you where a patient dies. That patient was somebody who earned a lot of money, and they have a large claim against you. They take the case to a jury, and unfortunately, the jury finds that you didn't meet the standard of care, that there was malpractice, and they return a jury verdict against you for $5 million. If you have insurance with $1 million of occurrence, then your insurance company is going to say, okay, we just paid them the $1 million. And the person that sued you is going to come knocking on your door saying, where's my other 4 million? And so that the amount of insurance you have is the amount of insurance that they'll pay against a claim, even if the claim is more than the amount of insurance you have. So you want to hear a bigger number than 1 million, 3 million. You want to know what their total coverage is, including excess policies that they may have in place. Some states, if you're lucky, like the state I am in, which is Indiana, we have a total cap on damages, which right now is $1.8 million, and you can receive full coverage to cover you for the full $1.8 million. And you never have to worry, even if there's a $5 million judgment against a provider or physician in Indiana, the court reduces that to the cap on damages we have in Indiana of $1.8 million. Well, there's only 4 or 5 states in the country that have an absolute cap: Indiana, Nebraska, Louisiana. I'm not sure where the other one is, maybe Arizona, have an absolute cap on damages. The other states, some states have caps on things like they call non-economic damages, pain and suffering, but they don't have any cap on economic damages, things like that. So you're always going to be at risk if there's not enough insurance. You want your employer to have as much insurance as they can, and you want to know what that level of insurance is. And the bigger the employer is, probably the less concern you have about that, because they're going to be on the hook for your acts or omissions as well. So if you can't pay, they may very well go after your employer to get paid in if there's not insurance and you're not able to pay. But you want to know what the insurance is. So the second aspect of insurance to be aware of is occurrence-based versus claim-made policy. Occurrence-based means that you're going to be covered by the insurance company that was covering you at the time that the act of malpractice occurred. So if the act of malpractice occurred September 1 of 2025 and you were insured by insurance company A when that occurred under an occurrence policy, and the statute of limitations on that claim is 2 years, and you don't get sued until December 2026, since September 1 of 2025, you've left that employer, you no longer have that insurance, you've gone with a new employer, and when the suit actually comes in December of 2026, you're with a new employer and their insurance says we aren't going to cover you because that didn't occur while you were working for us. That carrier that provided you the occurrence-based insurance will still provide insurance for you, even though you no longer work for them. The company that had that insurance, or even if that insurance is no longer writing for that company, because their policy says they will cover you for any claims that are made while you have the policy, any claims that occurred, hence occurrence-based, while you had that policy. So that's good. If you have a claims-made policy, the policy will cover you so long as the claim is made while you have that policy. So if you, in my same scenario, you're sued on September 1 of 2025 and there's a claims-made policy, and then you get sued on October 1 of 2025, that claims-made policy will cover you because you were there insured by them the time the claim was made. If you leave in December of 2025 and don't get sued until December of 2026, that claims-made policy will not cover you for that act of malpractice, because when the claim was made in December of 2026, you were no longer covered by that claims-made policy because you were no longer employed by that same employer that had the claims-made policy. So what do you do in that situation if you leave? If you leave, you want to make sure that you have tail coverage. The second bullet point, you want to have tail coverage. And that tail coverage basically says if you had a claims made policy, you can pay us some money to cover you for anything that occurred while you had that claims made policy, so that you can make sure that you will have coverage even though you had a claims made policy at the time and even though you've left that employer. And so one of the things that's in your contract is you're going to want to know if you have an occurrence-based policy or claims-made policy. In the contract, you want to say, if you have a claims-made policy, that you knew that the claim that you bought the tail coverage that's going to cover you for that period of time. The question then becomes, do they pay for the tail coverage when you leave, or do you pay for the tail coverage when you leave? You want them to pay for the tail coverage. Sometimes they will, sometimes they won't. I've also seen it where if you leave because without cause on your own, you have to pay for it. On the other hand, if they terminate you without cause, then they have to pay for it. So I've seen that handled different ways. You're always going to want to look in a contract about indemnification. Indemnification is where if you are held responsible for something because of them, or they are held responsible for because of you, you can be required or they can be required to pay attorney's fees and other things to defend the other party because of the acts or omissions of the indemnifying party. I don't like indemnification clauses. They can put you in a difficult situation. They're rarely enforced, but I don't like them. They're usually not a reason to have a deal breaker, but just do be aware of those types of things. Then finally, non-compete and non-solicitation agreements on this area. They have to be reasonable geographic time and restrictions, meaning they can't restrict you typically from a whole state. Generally, a non-compete is not going to be valid for more than 2 years. The other things I'll say about non-competes is non-competes are being gutted, reduced, found in disfavor every day in the United States, particularly when it comes to healthcare provider. Many states are passing legislation that limits the ability to enforce non-competes against physicians. The reason for that is legislatures don't like it when somebody loses their longtime physician because of a non-compete. So they're passing legislation that's outlining many types of non-compete. They're not outlawed everywhere. Even where they are outlawed, they're not always 100% outlawed in every scenario, but they are less and less enforceable in the general marketplace for physician contracts. Having said that, while non-competes are typically unenforceable, non-solicitation provisions are typically enforceable. And the difference is a non-compete says you can't go set up an office somewhere else and compete with us. A non-solicitation provision says, yes, we're not going to stop you from go setting up an office somewhere else. What we are going to tell you for a year or 2 years is that you cannot directly or indirectly contact patients and tell them to come over to you. And we're going to tell you for a year or 2 years, you cannot directly or indirectly try to hire employees away from us. And even if a non-compete's not enforceable, a non-solicitation typically is enforceable. Now, that doesn't mean there's not ways around that to speak of. Doesn't mean that you can't, it means you can't send a letter directly to patients, but you can advertise on social media, billboards, or whatever that Dr. Smith's now opening a new office somewhere else. You just can't go directly to those people and try to get them to come to your office. They can come to your office if it's their own choice, not you soliciting them, but you cannot solicit them in that situation. The other thing that's still going to be enforceable are confidentiality provisions, things that govern things like trade secret, patient lists, policies and procedures of an employer. Those are going to be protected by confidentiality provisions that are going to be in your contract. And so you can't just pick up and leave and take all of the information from one practice to the other practice. Medical records are different. Patients control medical records. Patients are always allowed to direct where their medical records go. So patients are going to be able, you may have to go through the patient to get those medical records. In some circumstances, based upon state law, you may be able to get those records directly from the providers. So negotiation strategies and tactics, common mistakes, accepting the first offer without negotiation. You certainly want to talk with those things. Your ability to negotiate is based upon how desperate they are for your services. If you're in a high demand, low supply area, you're going to be much better positioned to negotiate with them than if you're one of six people looking, they're considering you with six other people that could also fill the job. If you're one of six, they're probably not going to negotiate much. If you're somebody they desperately need, they're probably going to be willing to negotiate greatly. Now, that doesn't mean that they're going to negotiate right out of the block. I can tell you some of the things you're going to hear. You go back and say, I'd like to change this or I'd like to change that. First thing you'll hear from a employer is, this is our standard contract. We don't change it. If we changed it, then we'd have to change it for everybody else, or it gets too confusing if we change it, so we won't change the contract. Well, if they don't, that might be one of those things that is a deal breaker for you. And if they won't change it and there's something important for you, that may be the deal breaker. Or you may tell them, well, if you can't change it, then I'm going to have to look elsewhere. If they really need you, my guess is their story will change. That's their first pat answer because they don't want to change it and they'd rather have it not be changed. But if they need you and they want you, then they're probably going to be willing to negotiate on it. Focusing on salary and ignoring other terms. You do want salary is obviously important, very important, maybe the number one issue, but you also want to make sure you understand where they can take you, what they can do, other things like that. Failing to get agreements in writing. This is incredibly important. Every contract that you sign is going to have what we in the legal profession call a merger clause. Oftentimes it's called in the contract, quote, entire ENTIRE, entire agreement. And that clause will say that this is the final agreement between you and me. If it's not written in this agreement, even if prior promises were made to you, those prior promises are not enforceable. So anything that they promise to you that doesn't get into the contract in writing is not going to be enforceable by you. Doesn't mean necessarily that they don't intend to live by whatever they promise you as they're trying to get you to sign the contract. It just means that they don't have to, and things change. 3 years from now, the person who promised you that is gone. They've taken a whole new ownership, a whole new directors there, and you say, no, wait a second. Joe, when I was here, said that I would always have access to this office. And he told me that I would always have this so long as I had a contract. And they say, it's not written in the contract anywhere. Sorry, we're not going to abide by that anymore. So understand that if it doesn't make it into writing into this contract, it's not binding. And then not understanding compensation. I oftentimes see very sloppily written compensation provisions that talk about gross income, net income, reducing things for expenses, but nowhere are those things defined. Nowhere are the RVU calculations defined or how that transmits into what your actual salary is going to be. It's very important. If there's something in the contract that you do not understand, then you need to ask about it. That's the most important thing that I do with you when we walk through a contract is to make sure that you understand every clause. Don't just think you know what it means. We need to know what it means because where difficulties come up between you and the employer, when you understand the contract to say one thing, they understand it to say something else. And when you read the contract, it's ambiguous enough that both of you might be right. We want to make sure both of you understand the same thing before you sign that contract because that's how things go south quickly a year, 2 years, 3 years, 5 years after you sign that contract when something comes up and you both understand an ambiguous term of the contract differently. When to push back, priorities, what's non-negotiable? Is it call? Is it location? Is it non-compete? Be aware of that. Be flexible on lower priority items. Absolutely. There's things that I might not like in a contract, but I'll often tell it's not worth fighting over that. I just want you to know what it says, know that it's not advantageous to you, but it's not something that you want to fight over. Maintain professional relationships throughout. You never know, even if this contract falls through, you'll never know when the future might bring the two of you back together again. So never burn bridges. Document all discussions and agreements. Good to have that. and follow up in writing after verbal agreements, and certainly make sure that those either get in the contract, or if the contract's already been signed, you want to make sure that you enter into an addendum that incorporates whatever's been changed into an addendum or amendment to that contract.
So one thing that I have to add in, or else, our principal consultants, especially this one, really wanted to reiterate this fact that it is always good for a physician to state and reiterate sincere interest in the role while negotiations are taking place. If you are going through this process, and it can be obviously, as you've mentioned, a very long process, um, you want to make sure that you are communicating with the employer that you are very, very interested. Otherwise, it may come across that you are not that interested. Maybe you have multiple offers, that you're not really committed. So basically, the biggest suggestion in the contract negotiation process from the physician recruiter's perspective is to just make sure that you reiterate that interest.
All right, red flags when to walk away, unwillingness to negotiate reasonable terms can be a red flag. Depends on how critical those terms are. Excessive or unreasonable non-compete clauses, I'd be concerned about those. I think we're going to have a time here in the next 5 years when most non-competes are gone from contracts. There may be federal legislation that eventually removes them. Don't know. Inadequate malpractice insurance, that's why you want to know really what is their total coverage. I understand what you're telling me my minimum's going to be, but I want to know what you actually practically have in insurance. Vague or missing tail coverage provisions, you want to get that straightened out. Pressure to sign without attorney review, that would be a red flag for me. I would be surprised if most sophisticated employers would do that, but that could be something. Significant misrepresentation of work conditions. It's always good to try to check with somebody that works in this practice to know what the actual working conditions are, and do they deliver on what they promise in the contract. So always try to get in contact with somebody that's already recently joined that practice, or maybe was in the practice but is no longer. Try to have the opportunity to talk with somebody that's actually been in the inner workings of that type of practice. Red flags and when to walk away. Contract terms pose significant career risk. Employer refuses reasonable protections. Values misalignment becomes apparent. Better opportunity emerges. Trust has been fundamentally damaged. All of those are certainly red flags. And that's where I go from the beginning, where I started this discussion. Make sure that you're in a situation where you're aligned with the people you're going to be working with. You have the same goals, same values. It's a good place to work, and you're comfortable in that environment with the people you're going to be working with. Engaging a contract attorney. Again, first employment contract, it's always advantageous to sit down and talk so you know what you're looking about. Certainly, even if you've had a contract employment, if you get into that partnership agreement, that's going to be a time it's very important for you to negotiate with somebody. If you're asked to sign, sometimes you can be asked to sign restrictive covenants, non-competes, non-disclosure agreements, even after you're employed. Anytime you are asked to sign one of those, I would have legal counsel uh, consult with them. It's oftentimes not as expensive as you may think it is to consult with legal counsel. Complex compensation structures, you may want to contract with legal counsel. You may also, and I oftentimes advise this and tell people that it's good to get a tax or accounting advisor financial advisor that can uh, advise you on compensation, tax planning, tax benefits, that type of thing. In any contract you don't fully understand, as I said, one of the most important things that working with a lawyer can do is to make sure that you understand the contract language and what can and cannot happen under the contract. Before signing the letter of intent, that is ideal, so that when you get the letter of intent, or we're talking about drafting a letter of intent, we can talk about, or you and an attorney can talk about what you want in there. Upon receiving the full contract, you definitely want to get into us as soon as you can at that point in time, early enough to allow proper time to review. Not always possible. I understand how that is. Typically, the fee structure for reviewing a contract is going to be a flat fee for contract review, an hourly rate for negotiation assistance, and typically it's going to be one of those two. I typically do it for a flat fee contract rate, which involves reviewing the contract, making written comments on that contract, and then typically spending somewhere between 45 minutes and an hour and a half on a Zoom call where we go through that contract. I'll do that for a flat fee. Hourly rates, if you're going to get more involved in negotiations from beginning to end, where you're the contact, you're negotiating, that's typically going to be done on an hourly rate. My flat fee right now for contract review is $500 is my flat fee right now for doing contract review, the typical contract. There can be some outliers on that, and that's subject to change at different times. Hourly rate for me is $350 per hour. And then attorneys outside, you're going to be able to find attorneys at various geographic locations that might be anywhere from $250 an hour to 750 or $1,000 per hour that might do this kind of work for you. So, but it's probably not going to be as much as you think. And to engage somebody to spend a couple hours with an attorney, to have an attorney review it, as this last bullet point says, and it's an investment in your career protection. It's going to help you immensely in understanding what you're getting into and where the pressure points in and the do's and don'ts.
That's great. You've covered so much today that I know a lot of our consultants will love sharing, certainly with their candidates and physicians. We had a few questions actually submitted from them, the questions that they get very frequently from their physicians. So we've kind of touched on a lot of these. So first, what is the best strategy for beginning contract negotiations?
I think you just need to you need to get the contract, quite frankly. You want to see before you letter of intent, you want to have what's important to you, get some of those. If the salary is not in your range, you want to do that. After you have a basic agreement as somebody you're interested with, the first step is getting a copy of the contract so you can go through it and understand what the terms are.
Great. So you talked a lot about non-competes, and you did talk about how it's expected that they may not exist in the future. One question they frequently get is, can they be just deleted altogether from the contract or at least reduced in miles?
They can be deleted altogether from the contract. I'm seeing more and more contracts that don't even have a non-compete in them. You can certainly modify the term, the length of it, 1 year or 2 years or shorter. You can also reduce the geographic range. So that's a possibility. The other thing you can do is provide terms like, hey, if you terminate me without cause, you, the employer, terminate without cause, or if I terminate this contract because you breached this contract, then the non-compete should not be enforced against me. It doesn't seem to me fair that you can enforce a non-compete if the employer is the one who made the decision to terminate the contract. I should be able to go out and work. So there's other modifications you can make to a non-compete.
And is it common to negotiate malpractice tail insurance or nose coverage?
Yes, you're going to want to ask about it, and you can always talk to them saying, hey, if I leave, I do not want to have to buy my own tail coverage. And sometimes contracts will actually say not only do you have to buy tail coverage for yourself, but you also have to buy tail coverage for your employer. So you definitely can negotiate that. And my negotiation would always be, hey, employer, if I leave for whatever reason, you should be paying my tail coverage. I shouldn't have to pay it.
And this one is more private practice related. So they asked, how do I ask a group I want to join about the path, anticipated cost, and return on investment for a partnership in a private practice? Are there documents that I should ask to see?
Yeah, you're going to want to see, you may want to see information regarding their spreadsheets, their financial statements, their income statements. You may want to see their tax returns. You're going to want to have some due diligence, and this is where having that advisor, your tax or business advisor, as well as potentially an attorney to look at documents they have. Now, they're not going to give you that before you start working for them. But if it gets to the point where you're serious about potentially becoming a partner, they should be willing to share financial information so you can do due diligence on whether or not you should invest in that practice.
We get a lot of questions about private equity, as you can imagine. So, someone asked, how do I discuss and protect myself from a future private equity takeover by a group I plan to join?
Okay. So it depends what kind of protection you want. You're generally going to be able to have your contract's going to probably give you the right to terminate without cause, as we talked about. So if private equity takes over and you don't like it, you're probably going to be able to terminate your contract without cause. You certainly, if they come in and take over, what you would want is some provision that would say if there is a non-compete, you may want to say, hey, if you're taken over by private equity, I want you to agree to waive. There would be no non-compete. You can also there's sometimes a golden parachute option where, hey, if you get taken over by private equity, I can terminate this contract and you'll agree to pay me instead of for 90 days, you'll agree to pay me for 180 days or something for that. Now, all of that is based upon the other side, the employer being willing to give you those kind of protections. They they very well may not give you those. Ultimately, your only real protection may be your right to terminate the contract without cause.
And our last question, and I think this one's really interesting given all of the elements that can make an employment contract so layered and complicated. How do you compare offers? So the numbers are one thing, but once you add in things like tail, RVU, partnership, and call, it starts to feel like apples to oranges. What are some tips on how to line things up to make a fair comparison?
Yeah, I think what you need to do is do that, do that, put two columns down and determine what's important to you and prioritize what's important to you and which one meets those priorities best. It is somewhat difficult to compare contracts. On the other hand, and I've looked at hundreds of contracts, I've looked at them from all over the country. The contract that you're going to get in California is going to look amazingly similar to the contract you're going to get in Tennessee. Employment contracts, especially as time has gone on, because of regulation, the laws, the competition, they have become looking more and more the same on the basic terms. Now, those important terms like compensation, non-compete, tail coverage. I wouldn't put tail coverage in the same category as non-compete. Tail coverage sometimes is not that expensive. So while it's important, it's not necessarily overly important. And so I think you need to prioritize and then determine. And then I think the tiebreaker may be is which place feels best to you. Where do you want to live? But even more than that, who do you want to work with? Who do you feel better practicing with? Where do I think I can grow the most? Where am I going to have the most opportunities?
Well, great. That's fantastic. Jim, thank you so much for everything that you talked about today. It's incredibly informative and incredibly helpful. I know that our consultants appreciate it. I know a lot of our physicians are going to appreciate it. So if you want to get a hold of Jim, his email and contact info is right there. And if you want to check us out, you can check us out at stjohnjobs.com or email us at jobs@stjohnjobs.com and we can connect you with the consultant in your specialty. Jim, thank you again.
Thank you. Good luck, everybody.